115834, State of Kansas v. Jonell Lloyd.
May it please the Court, Clayton J. Perkins of the Kansas Appellate Defender's Office appears on behalf of the defendant appellant Jonell K. Lloyd. I would request 3 minutes for rebuttal.
3 minutes is granted.
In way of brief factual and procedural summary of this case, Mr. Lloyd was convicted in 2009 of premeditated first-degree murder, felony murder, and child abuse of his 17-month-old daughter, who I will refer to as CB by her initials. In his appeal after his conviction, the district court imposed a hard 50 life sentence with a possibility of parole after 50 years through the enhancement procedure allowed by the district court at that time. During his initial appeal, the United States Supreme Court's Elaine case came out, and because of that, on his appeal, his hard 50 sentence was vacated and remanded because the sentencing factors had to be found by a jury. During that appeal, he also raised a issue about the voluntariness of the only witness in the cases, the only direct witness in the cases' statements and testimony that was not properly preserved for purposes of appeal. Once the case was remanded back, the state filed notice of intent that it would be seeking a new hard 50 jury trial. And so this appeal comes from the hard 50 sentencing trial, where the only points before the jury were whether or not he had, there were 2 aggravating factors present, whether he had a previous conviction for inflicting great bodily harm, disfigurement, or other descriptors, and whether it was heinous, atrocious, and cruel, and finally, whether or not the presence of those aggravating factors was not outweighed by the presence of mitigating factors. And that brings us to the first issue we raised on appeal, which is the basically re-raising of the point that was brought up in his very first appeal.
And if it wasn't properly preserved then, what resurrects it now?
Well, I believe first the statutory authority in these resentencing trials, which limits the rules of evidence from basically the rules of evidence don't apply, and the only rule of inadmissibility is whether or not the evidence was obtained through some sort of constitutional violation. And because this is a 14th Amendment due process violation, I think that can come up now. I don't know, given the weird specific procedural nature in this, I don't know if anyone would ever be trying to raise a suppression issue for the first time before the sentencing phase normally. But it came up here because it never came up before. I understand the state's argument has a fair number of procedural issues with the way this was preserved. The analysis that we laid out in the brief is basically takes whether or not her Miss Loudermilk's initial statements during police interrogation were coerced, and then asks whether or not that coercion continued throughout her testimony. The state's argument regarding that preservation, I believe, is basically we preserved only an objection to her subsequent testimony, but not her initial confession, which I think the two are so highly interrelated and the analysis is the same that I don't know how you could even get to the second point, whether or not her testimony was impermissible.
But there is a significant factual difference, timing difference between what she said prior to trial and what she said at trial. And that is that the Sink case had been filed, that ship had sailed, what she'd been threatened with in her original statements was no longer a threat by the time she gave her trial testimony, right? So that distinction might mean something to us.
Yes, that distinction does mean something, although I would disagree that the ship had sailed at that point, because my again, we don't have the record from the Sink case because those are a separate case and
Sure.
confidential, but my reading of the record is there's some statements on there that the Sink case was ongoing, and maybe
Still
it had been
pending.
filed, but the primary concern here is that the state was both calling her to testify about this initial coerced statement that was coerced based on many statements involving the custody of her children, how officers were going to help her, how they were going to take away those children. And then throughout the trial and the preliminary hearing before that and then the trial, the state was basically going through the court proceedings to take those children away.
Okay, so it's your understanding the Sink proceeding was still pending at the time of her trial testimony?
Yes.
Okay,
yes.
thank you.
And was it the crossing? You're complaining that basically that all the statements made by Ms. Loudermilk were coerced.
Yes.
And she's a witness in the case, not the defendant. And as the district court judge pointed out, there is a distinction between the right that's being asserted here based upon involuntariness for a defendant. You're getting the Fifth Amendment types of concerns. And here, I guess it's more of a due process kind of concern on behalf of your client. Mm-hmm. And that was pointed out by the trial judge. I guess basically and those statements about the coercion were specifically addressed in cross-examination by defense counsel at preliminary hearing. Mm-hmm. Why doesn't that get to the voluntariness of those statements? And that's the mechanism by which the procedure was satisfied. There was extensive cross-examination regarding the police action. Is she being coerced to testify then, or to make a statement then? Is she being coerced now? That inquiry was made at preliminary hearing, wasn't it?
Yes, and there was additional cross at trial about it.
Right.
And
So why doesn't that cure the problem that you're having with this? Is that it was the voluntariness finding, or the jury could certainly weigh that at that time?
because the jury weight might be a slightly different question, but
It's a credibility determination about whether she's testifying truthfully,
yes.
and the inquiry was made about the very factors that you're concerned about.
Yes, and the inquiry, I would argue, supports the fact that this was coerced testimony. She described that she had these ongoing cases and that she was under the understanding from her caseworker, at least, and possibly the district attorney's office.
But the questions were asked that, are you testifying truthfully? Did that have anything to do with your impression of what occurred on the day in question? I mean, she said no. The fact that I was made aware of what could happen with my child did not enter into what I'm testifying in today. I mean, wasn't that what she said?
I believe she may have said those statements. She also, I believe, said that she was only there because of either the subpoena or these ongoing other cases.
She's a witness. She's there because she was subpoenaed.
Yes. Yeah. Well, that is true. But
she didn't show up for the subsequent jury trial.
And regarding the sort of procedural coercion of an ongoing child custody case, I think that does say a lot, that 5 years later, by the time that case was certainly over with, that she did not appear.
But isn't that two questions, whether her appearance was coerced or whether her testimony was coerced? She could be there under threat of some adverse action in the sink and still tell the truth.
And that is true.
I think that's what my colleague's getting at, is that was tested in the crucible of cross-examination on the truth. And so why shouldn't we give credence to that?
And I think it's because of the inherent coercive nature of this whole process, coming from those initial statements to the ongoing Sink case, to the reality that what would happen if she got up on the stand and said something other than what she had told the police officers, because she was already arrested originally for obstruction for saying something that the police officers took as a false statement. So when in this particular instance, is she even going to do? If her testimony was untrue, or her statements during the interrogation are untrue, she's looking for some sort of obstruction charge that they already threatened her with once. Unless the court has more questions on this.
Did you argue anywhere that the in your briefing, I didn't see it, where the statutory factor that the crime was committed in an especially heinous or atrocious cruel manner, you didn't appeal that?
No, it didn't challenge the sufficiency of that.
Sufficiency of that finding, okay.
Yes. I would briefly like to discuss the sufficiency of the prior conviction.
Why does it matter once there's a finding that if there is a finding that it was especially heinous, atrocious, or cruel, doesn't it just take one of the aggravating factors?
Not under this statutory procedure, because the jury has to find that the aggravating factors are present and not outweighed. This statutory procedure asks the jury to do a balancing of the aggravating factors that were present versus the mitigating factors, and then they have to come out with their verdict.
So your argument is the presence of two aggravating factors may not have been outweighed, but perhaps the jury would have decided differently if they only had to weigh one aggravating against the mitigators. Is that your argument?
Absolutely, yes. And I think the aggravating factor of the prior conviction has to be something that's a factor to the jury, or else the state wouldn't have put it before the jury.
And what were the mitigators here?
The mitigators were Mr. Lloyd's history of abuse as a child, that he was put through a great deal of abuse, and that even there was a witness who was his counselor during some, I believe, juvenile proceedings, that basically said when she got to his case at a very young age, it was obvious that he had already been through a great deal of abuse and was troubled. But regarding that particular factor, the crux of my argument is that it's an assault conviction, and you don't inflict bodily harm during an assault conviction. They're pretty exclusive in that regard. This wasn't a battery, and
Isn't the aggravating factor commission of a felony which results in great bodily harm? It doesn't say that the statutory elements of that crime has to satisfy great bodily harm. It says as a result of the commission of the felony. We don't go to the specific elements, do we, or do we?
I think we do. I think that there are sort of two sets of cases. There are cases where you're going to deal with crimes that involve inflicting bodily harm, and then implicitly, whether it's an aggravated battery
So
or
in this
murder,
case, aggravated assault can never result in satisfying that factor.
No, because it's not a crime where you're convicted of any physical contact.
And that's your argument?
Yes, that is mine. And to briefly touch on my last one, I understand this court has already ruled on the ex post facto issue. I'd be happy to answer any questions about my briefing on it, but otherwise, unless this court wants to revisit that issue, I understand it's...
Do you have any rebuttal to the rationale of those cases that have found it does not violate ex post facto?
My argument, honestly, is pretty much the same as in those cases, that you're finding new elements. But I know that has already been addressed.
Any more questions?
Factual question as to the harmlessness on that first issue. Did the detectives who took Ms. Loudermilk's statement testify at the sentencing hearing on remand?
Detective Lenny Rose, I believe, testified. I don't think the other ones...
About her statements?
Yes.
Did he testify about her statements? And was there a contemporaneous objection to his testimony?
There was not one lodged before. The defense counsel got a continuing objection.
It was afterwards, right? Did he move to strike, or was there... Go ahead. Was there an objection at all?
Well, it came up at basically the start of the trial that day, when it was sure that Miss Loudermilk was going to be unavailable. They addressed all of the various issues. I believe defense counsel then asked for a continuing objection. And then I think when Ms. Loudermilk testified, the district court reminded defense counsel to object again.
Was that earlier objection broad enough to cover the detective's testimony?
I think it has to be, given the analysis going on with this issue, that you basically can't get to this issue without those other statements being initially coerced.
But there was no objection at the time they initially testified prior to the Ms. Loudermilk's testimony being read. That's right.
There was a continuing objection that was granted.
Specifically to the officer's testimony?
No, I don't think it did address the officer's
Thank you.
testimony specifically.
Any more questions? Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. The first issue before the court challenges the district court's admission of Tamika Loudermilk's testimony at the time of resentencing. In order to obtain the relief requested, the defendant has the burden to establish that there was improper coercion during the investigative portion, and that coercion necessarily carried over to taint her testimony to make it unreliable. From a preservation perspective, I think this case is a little bit nuanced. Before the district court, the defendant argued against the admissibility of Loudermilk's trial testimony only, asserting that there was a deficiency in the reliability of that testimony because at the time she testified, she was suffering residual duress. The district court rejected the argument, finding that to the extent she felt pressured at the time of her investigation, that issue was no longer present at the time she testified because those sync proceedings had already been initiated. It subsequently came out through the reading of Loudermilk's testimony on volume 9, pages 86 and 88. She specifically testified, those cases are concluded, and I no longer have custody of my children. Before this court, the defendant places a more substantial focus on the coerciveness of the investigative questions that were asked. But during the resentencing proceeding, counsel for defendant specifically stated her testimony is unreliable, and then in preserving the objection, he said, I'm specifically asking that that testimony be kept out. The defendant is free to argue a violation of his due process based upon a third-party witness's coercion if he can show that the trial testimony was actually coerced and rendered unreliable by a prior coercion. That burden hasn't been satisfied here. Before the district court, there was not evidence offered. There wasn't a proffer made that tended to demonstrate that Tamika was subject to coercion at the time of her investigative statements. A proffer likewise was not made to substantiate a claim that ongoing coercion existed at the time that she testified. Rather, counsel simply asserted she was under duress from that previous investigation. Well, those conclusory statements don't satisfy the burden. Accordingly, the only portion of the inquiry that's properly before this court is whether the district court erred when it kept out Tamika's testimony. And when that analysis is conducted, the district court ruling should be affirmed because there is no indication of duress. Tamika specifically testified that the allegation of duress focuses on her children. Tamika specifically testified that issue does not remain. The cases are concluded and the children are no longer in my custody.
Did she have prior statements, though? Had she already made statements that if she changed her story at trial, that she would be subject to personal criminal acts?
Are you asking were those statements made to her? I didn't hear the first part of your question.
Well, the coercion of the children may have been gone, but I'm asking about the coercion of having made a prior inconsistent statement when you're testifying under oath.
That
You
wasn't
understand
I
what
do
I'm
understand
saying.
that, but that wasn't the specific allegation.
Okay.
The specific allegation at the time was her testimony was coerced because she was threatened with these issues regarding her children. So that would insert a new angle into an already convoluted water.
But what, am I remembering correctly that she testified that her caseworker told her that her chances of getting her children back were increased if she cooperated or
I
testified?
believe
I mean, I don't remember exactly what she said.
that was at the preliminary hearing.
Okay, so that was before.
Yes. Because she specifically, if you could indulge me just a moment here. I don't see that in her direct testimony. I'm fairly certain that was at preliminary hearing. Yes, she specifically testified, volume 9, page 69, at the time of the prelim. My understanding was that if I cooperated with the state, that would help me get my kids back. And then she says right after that, the kids are not in my custody. And later on page 86 and 89 or 88, 86, she says, no, I did not get my kids back. I still don't have them. And then follows up on 88 on recross that the case involving my children is over. The defendant acknowledges that the district court's ruling does not encompass the pretrial statements, and most likely because that was something that wasn't raised. That isn't something that this court should take forward on appeal for the first time. The defendant argues that this is simply a question of law that this court can entertain for the first time on appeal. But in order to get to that question of law, we first have to have that factual foundation. And that factual foundation has not been provided here. If this court were to accept defendant's request and were to undertake an analysis of those facts, it would go through the same factors as you would with the defendant's voluntary statement: the manner, the duration, the fairness, her age, and her intellect. And when we look at her age, she was 21 years old. The duration of the interview was 4 hours, 15 minutes roughly. As far as the manner and the fairness, we have to look at it overall. We can't just focus on Officer Nagy's statements. There was no excessive force. The interview was professional for the most part. They made her comfortable. And when she was cold, she had a blanket. And when we're looking at the totality of the circumstances, and when we're going to focus on Officer Nagy's statements, then we also have to focus on the way Tamika responded to those statements.
How do we do that when the district court never did that?
Well, that's what I'm saying. I'm just saying if this court is
I
inclined to go down that
understand
road.
if we get way down the road to
Right.
that point, the problem is that analysis never occurred.
Yeah, you can't do it, but just for the sake of completion.
Right.
And if the court's not interested in going down that road, I completely understand. Anyway, the harmlessness aspect of it, to the extent the court disagrees and concludes that the court erred in declining to allow that testimony in, there's no reasonable probability that it contributed to the sentencing verdict. The jury still received evidence through other witnesses that testified at that resentencing, what the situation was like regarding Shavira's 2 days proceeding with the defendant, the substantial abuse that she endured, the suspicious circumstances of her disappearance, where the body was ultimately located, and the condition of the body when it was discovered. Defendant is not entitled to relief as a result of this issue. I would like to touch briefly on the sufficiency of the evidence regarding the aggravating factors relied upon by the state. Primarily, it's the state's position that it's really of no moment because the jury found there were 2 aggravating factors, that being the especially heinous, atrocious, and cruel. I believe that the jury is only required to find one. They're not required to find both.
What about the balancing?
The jury, in my mind, the jury balanced those mitigators against both. I don't think the jury balances as a collective whole. They balance against, do those mitigators balance against the especially heinous, atrocious, and cruel, and what is the effect of that? And those same mitigators balanced against the aggravating circumstance of the prior felony.
What do we have in the record that tells us that's how they go about it? Are they instructed to do them separately like that? Don't
I-
they just take the aggravators in one pot and the mitigators in the other? And
But I don't think that it's a collective whole. They're told that these are the aggravating circumstances relied upon, and I would presume that since they are specifically or separated out, that the jury would consider each of them individually. Was this especially heinous, atrocious, and cruel, and was the aggravator established that he had a prior conviction?
yeah, I don't disagree with you that the jury would understand that it is supposed to evaluate the existence of each of the aggravators separately. I get that. I was just trying to get you to respond to your opposing colleague's argument about the balance is still a second step the jury has to undergo, and if you cut out one of the aggravators, the balance may weigh differently. That's all.
And I guess I don't necessarily agree.
I understand you
with that
don't
approach.
agree, but is there something in the record that supports that?
There's nothing that specifically says what process the jury undertook, just that they found both aggravating factors and that neither was outweighed by the
And
mitigators.
so under your analysis, or the way it happens, the jury could impose the death sentence based on one aggravator, but life without parole based on another aggravator.
Well, we're not dealing with the death sentence here. We're talking about the hard 50.
Or
So
hard 50, I mean, saying, okay. They could impose the hard 50 on one aggravator and not on another. I mean, that makes no sense to me. We have one sentence we're dealing with, and so the independent balancing.
So I guess from that perspective, are you proposing that the state can only submit multiple aggravating factors? That
No,
there can never
I'm
be a single?
proposing that the aggravating factors have to be not outweighed by the mitigating circumstances. And that's what happens, is you do a balancing test to determine one sentence. And if you take one of the aggravators out, it changes the calculus. Or could change the calculus, at least it changes the analysis. And so I don't know how we can say, well, there was one anyway, so we're sure that that would have been enough.
I think we have to trust the process at some level. The jury is entrusted with the responsibility to weigh these mitigators. They're specifically instructed that they have to weigh these mitigators against these aggravators. I don't think that it's a collective whole, that they are required to find all in order to impose the sentence. To me, that doesn't make any sense. If they were to find that this wasn't especially heinous, atrocious, and cruel, then I don't think they're
But they
precluded
did
from
find
finding.
both of them. They
Yes.
did find both of them, and they weighed both of them against the mitigating circumstances. They didn't pick out individual mitigating circumstances. All of the mitigating circumstances did not outweigh the two aggravating factors that were determined.
And I absolutely agree with that.
And you take away one aggravating factor, and I'm asking you, how can we assume the jury would weigh the same way if there's only one aggravator versus 2 or 3 or 4 or 5?
Why-
It seems to me the more aggravating factors there are, the tougher it is for the mitigators to outweigh.
Why would they weigh any differently? It's the same mitigator. Does the fact that he's abused excuse the fact or weigh against the fact that this is especially heinous, atrocious, and cruel? Does the fact that he's abused weigh against this? I don't understand why it would be any different to view them collectively, and somehow how the weight or the impact of those mitigators differs when you're looking at possibly just one. You would go across and determine how that mitigating factor impacts that aggravating factor, not how this one mitigating factor impacts this body. You would have to look at them individually.
We just that's the problem. We just don't know that I mean, you're right. The jury might come out with the same result, but we don't have anything that would give us an indication that that is the case.
No, we don't have an indication that this is precisely the process that the jury undertook. The jury was instructed that they are to weigh mitigators against aggravators. I think it's fair to possibly assume, or to at least take into consideration, that they would follow that responsibility and look at each factor individually. Why would they not consider each factor individually? It doesn't make sense to me that somehow a single aggravating factor is given less weight than multiple aggravating factors and somehow the balance shifts. If you were to give the jury the same instruction for a single aggravating factor, the process undertaken is no different than when there
You
are
don't think the
multiple
state's
aggravating
case is stronger when it has multiple aggravating factors? Is that what you're saying? I don't understand that argument.
What I'm saying, I'm not saying that it's not any stronger. I'm just saying they don't undertake a different process. They don't just consider
Well, the
them
whole
all
reason the state
collectively.
wants to pile up the aggravating factors is because it's easier to meet the state's burden.
Well, I don't think the state is undertaking some sort of sinister approach.
I don't mean that it's sinister. I mean it's perfectly appropriate under the statute if you have the evidence to support it.
If you
But
have
that's
the
why you do
evidence,
it.
if you have the evidence to support the aggravating factors, then yes, absolutely, you should put them all forward. The jury is instructed there to consider the mitigating factors against the aggravating factors. It would be the state's position that that process is no different when there is one aggravating factor versus when there are four.
Do you have any argument that would save the finding of the prior felony aggravator in this case?
Well, I think, yes. First of all, get to that portion of my argument. First, I would agree with Justice Rosen's position that the way that the statute is written, it specifically says that the defendant was previously convicted of a felony in which the defendant inflicted great bodily harm.
Is there any evidence that that is the case here?
Yes, there was evidence submitted through testimony that she sustained a gunshot wound, that she was required to seek medical treatment as a result of that gunshot wound. Detective Rose testified that that's the first place that he met her was in the hospital. So there is some evidence of great bodily harm. The state would also point out that, as we did in our brief, that in the defendant's original appeal, this court found sufficient evidence supported that prior conviction, which seemingly would conclude the matter. Now, to the extent it isn't necessarily binding, because that was kind of a unique circumstance in that you guys were making that finding so that it could be presented at the time of the resentencing. But we would nevertheless argue that the factors haven't changed. It's still the same prior conviction that was previously found to have sufficient evidence. If there
Isn't
are,
that the jury's role, though, to find that the evidence has been, the statutory evidence has been met, and the only argument that was submitted was, and it was basically an argument that nearly every gunshot wound results in disfigurement. Is that sufficient evidence to say that there was great bodily harm as a result of what occurred in the prior felony?
well, I don't think that was the only evidence that was
Well,
submitted.
shot in the foot. I mean, there's not any. We don't know much about what occurred there, and if you're trying to prove to enhance a sentence to 50 years, wouldn't it take more than just a statement that, yeah, I interviewed her in the hospital as a result of a gunshot wound to the foot? We don't know anything about what occurred there. If there's disfigurement, if there's great bodily harm. I mean, first blush, you get shot in the foot, yes, that would seem to indicate great bodily harm, but doesn't it take more than just seem to indicate?
Well, and I think we have to take the evidence collectively, because we also have a situation where Tamika's testifying that the defendant first pointed the gun in her face and then ultimately shot her in the foot. That I think if you're talking about a hospitalization and requiring medical treatment, I think it's going to require a little bit more than a mere grazing. And again, that would be the jury's determination to make based on all the evidence that's before them. And when they look at that collectively, hey, if she spent time overnight in the hospital, if she acknowledges that she was shot in the foot, then that would transcend normal bodily harm. It would not be a mere bruise, it would not be a mere abrasion, it would be something more substantial.
Counsel, I see you're out of time. Do you need 30 seconds to wrap up?
No, I would just say, if the court doesn't have any further questions, we would respectfully request that the defendant's sentence be affirmed.
Any more questions? Thank you, counsel.
I only have a couple of points on rebuttal, and I would like to initially preface this with the organization of the record is a little complex in this case with the remands and prior testimony. So I want to point out some of the sites I have here, I believe are to the correct volumes, but I was regarding Justice Lukert's question involving whether or not this coercion was asserted at trial. My notes have that Ms. Loudermilk was questioned in volume 11, page 38. I think it's actually 37 to 38. About was her understanding from her caseworker if she cooperated with the state that would help you in getting your kid back, and her answer was right. So I believe it.
You believe that was at trial, not a preliminary hearing?
In my notes, I have that marked as at trial, and I think I said that in my brief. So I believe those statements were there. Although I
But
haven't.
the Sink case at trial was completed. That's what she said anyway.
I have not checked volume 9, pages 86 and 88, so I'm not sure. My recollection is that there was actually a hearing sort of at the start of one of the days of trial about a conflict an attorney had with her ongoing Sink case. So I believe that was ongoing at the time. My second point is a few times the state said that the burden is on the defendant to establish a witness's coercion. And I believe that, at least under our present case law, the burden is on the state to prove as with basically all suppression issues, once it's been asserted, the burden moves to the state to prove the voluntariness of the confession. Although I don't think there has been a case up to this date involving the statements that go into trial, whether or not the burden shifts. I know different states take different stances on that. Finally, the evidence involving the hospitalization of Miss Loudermilk for the gunshot wound, I believe her testimony was she couldn't recall if she had been hospitalized for it. And I think that goes to this final question of the sufficiency of her testimony, because at trial and then as it was reread at this sentencing trial, she had very little detail about what happened that led to this aggravated assault conviction.
Does it take her testimony? What about the officer's testimony? That's where he interviewed her, and that's what he understood that occurred, that she was shot in the foot and had to be in the hospital. Is that sufficient evidence to satisfy great bodily harm or disfigurement?
I don't think it's sufficient evidence to prove he had a prior conviction in which he inflicted great bodily harm.
And why not?
One, because he doesn't have a prior conviction for inflicting it, but two, because there's not enough to even tie that testimony to his conviction. And three, because her statements would be the only ones that would have a real perspective on her injuries.
And is his testimony specific as to whether she was interviewed after she'd been admitted to the hospital or whether she was still in ER? Or, I mean, what can we tell from his testimony?
From my recollection of it, it's very vague that he didn't recall very much about that initial meeting with her.
Do you have any further questions? All right, thank you, counsel. Thank you both for your arguments this morning and this afternoon. The court will take this matter under advisement. That concludes